Okay, thank you everyone for joining us. It's good to be here, and I can see that both mentors are here. Armeli is here and Lolade is here. Thank you so much for joining us. Thank you for joining us. So we'll just go ahead to start the meeting. My name is Juliana Imam, and I'll be your anchor for today, pending when the moderator is here. I will just go ahead to read what we're about and then make a few announcements, and we'll go right into the discussion for today. So Gypsy Intellectual Property Mentorship and Internship Program is a quarterly program for students, young professionals, and enthusiasts across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. This program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch our videos by searching for Gypsy on YouTube and Facebook. Our hashtag is GypsyMIP. Our objectives are to provide easy access to quality professional guidance, training, and resource materials for students, young professionals, and enthusiasts in Africa, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to transform mentees into mentors and leaders for the next generation of mentees, and to facilitate further mentorship, internship, scholarships, and job placements for mentees. I'll also like to encourage the mentees to sign up for the 30 minutes private mentorship program. So if you see a mentor that you would love to have private professional discussion with, you can sign up for this program. So we know that not everyone might be able to ask their questions here, but if you have something and you really need to talk to a professional, so identify who you'd like to talk to, use the link and find their names, and then reach out to us, and we'll try to schedule a meeting between you and the mentor that you would like to talk to. I'll go ahead to read out the profile of the mentors that we have for today before we go into the discussion, so that once we go into the discussion, we will not be breaking it to read out profiles. Ololade Oloniyo is a transactional advisor skilled at reducing legal and business risk for clients across the technology, media, and film sector. She has worked with the national and multinational bodies providing compliance, advisory, management, privacy, and general business advisory. She regularly helps digital businesses, startups, and private organizations work through their projects, secure intellectual property rights, and negotiate contracts. She's the CEO of Intellectual Property Discourse, a social enterprise focused on intellectual property and innovation development in Africa. She is an associate of the Chartered Institute of Arbitrators UK and a member of the National Assembly Business Environment Roundtable NASBA Expert Network, and the founder of Starfield Business Consult. Our second mentor for today is Armel Talafuda. She is an intellectual property strategist and an experienced trade negotiator. She provides assistance and guidance to clients in intellectual property. Through her technical skills, she supports her clients from the beginning of their project and during the whole life cycle of their intellectual property rights. She is the Deputy Director of Cabinet TF and TNF and an observer at API, Association of Legal IP Attorneys of Cameroon, and the co-editor of the intellectual property news flash titled TFIP Spotlight. So with that, I would like to welcome everyone to the second week of the mentorship program. Thank you all for working together, cooperating, and ensuring that this program runs smoothly. So I'd like to thank all the mentees. With that, we go to our presentations for today. So we'll be hearing from Group 1. Group 1 has 7 to 9 minutes to be done with their presentations. Who is presenting for Group 1?
I am.
Okay, please go ahead to make your presentations and share your screen. Thank you. Over to you.
Good day all. My name is Cyril Cindy, and on behalf of Group 1, I'm going to be taking the topic, the importance of patents and trademarks to businesses. We're going to be looking at the meaning of patents, the requirements of patents, the meaning of trademark, the importance of patents and trademarks to businesses, and the conclusion. We'll start with what a patent is. A patent is granted under law to protect an invention that is new or essentially better in some way than what is made before, or for a better way of making it. In intellectual property, a patent is an exclusive right granted for a new, inventive and useful product. It can take the form of a new product, process, or technical improvement to existing invention. It is an exclusive right that allows the inventor to exclude others from making, using, or selling the products of his invention during the life of the patent. It's important to note that patents are only applicable in the country where it is filed and granted. Also, the patent right is limited to a period of 20 years. We look at the requirements of a patent. The first one is that the innovation must be new. You cannot patent something that is already publicly known, and as it would be unfair to confer the economic benefits of a patent in relation to something that is already publicly known. The test of novelty is assessed as at the date you filed your application for the patent. 2, the innovation must be inventive. This requirement of an inventive step relates to the obviousness of the new product, process, or invention. If it is obvious to a skilled person, it is not patentable. 3, the innovation must be skillful. And 4, the innovation must not have prior use. If you have been selling the product using the process in your business, or if you have licensed it, this prior use disqualifies it from being patentable. We are going to look at the meaning of trademark. Trademark, as the name implies, is a mark used in trading, that is business. It distinguishes one's business or brand and makes it easily identifiable. Mark in this context is not limited to literal marks, but includes words, logos, symbols, names, taglines, or a combination of any of the above. A trademark is that unique feature that a business has which makes it easily recognizable by customers and distinct from all other brands producing similar products or goods. For instance, Pepsi and Cola belongs to the same category of goods called beverages, but each product has its unique trademark which makes it distinct from the other. A trademark may be registered or unregistered. When a trademark is registered, it gives the business the exclusive right to use its trademark in relation to the goods and services it was registered for. If there is any case of infringement, an action can be instituted in that respect. However, in the case of an unregistered trademark, the owner may institute an action for passing off on its mark. More often than not, businesses are advised to register their trademark provided that it meets the requirements of the Trademarks Act. Section 6 of the Act provides for distinctiveness required for the registration of a trademark. Moving along, we'll look at the importance of patents to businesses. Patents are not just abstract concepts. They play an indispensable role in every business by rewarding ideas. Patents encourages the development of innovations and new technology. The importance of patents includes, but are not limited to, the following. We're just going to look at 3. It ensures the protection of an invention. A major importance of patents is that it ensures the protection of an invention. Once an invention meets the criteria provided under the Patents and Designs Act, a patent safeguards it for a limited period of 20 years. As such, third parties will not be able to create similar products within that period. 2, collaborations and cross-licensing. Patents can provide a platform or negotiating tool for enabling fruitful collaborations or agreements with third parties. A company's patent portfolio may cover something that a third party wishes to use to develop their technology and vice versa. In this situation, a company could trade access to their patent portfolio for access to the patent portfolio of a third party by cross-licensing. So having patents that are useful to third parties may open doors that would otherwise not be possible. And lastly, patents defend your market share. Using Amazon as a case study, the now omnipresent one-click purchase system was patented by Amazon. Some companies try to copy this process for their own use, but without success. Amazon sued them, filed a patent infringement suit against them, to be precise. So the retailing behemoth still enjoys huge competitive edge over all other competitors in the market. It won't be an exaggeration to state thus that it was this historical move which enabled Amazon to become an undisputed leader in online retailing. Let's look at the importance of trademarks to businesses. When your business holds trademark protection, it becomes easier for customers to locate your business and the services or goods offered. Whether they are on social media, browsing the internet, or walking around the neighborhood, your customers are able to immediately identify your company and available products or services when you use a trademark. We're going to look at other importance of trademarks. The first one is that it's a unique marker of identity. Trademarks are important because they serve as a unique marker of identity. One look at the trademark and the customer connects with a company. It could be the name on the logo, the design, or the colors. Customers do not even have to read the words to figure out what it means. One look should tell them what it is all about. For example, the shoe brand Nike doesn't always have the words on its logo, but most people know what the brand is all about. Two, it protects reputation. Another perk that trademark registration offers is safeguarding the reputation of a company. For example, Lamborghini is an expensive brand of luxury sports cars and costs a lot of money. Now, if a manufacturer of a less expensive car decides to affix that Lamborghini brand on it, it will cause a big loss of reputation to the manufacturer. Discerning buyers of luxury products won't be able to associate the brand with a luxury high-end product and desist from buying it. Naturally, it is in the interest of Lamborghini to ensure that no one else comes up with a cheap product of the same name and logo. Three, it strengthens the market footing. It can take years of marketing to get customers to accept goods. Some companies have trademarks that have been used for many years and have a reputation that is hard to beat. So it is very important for companies owning such trademarks to protect it from unlawful use so that its reputation remains undiminished. The Belgian beer brand Stella Artois has been using the same logo relatively unaltered since 1366. Naturally, it would want to be protected against any misuse. In conclusion, it's important to note that there are other advantages that trademark provides for business, including brand identification and protection, financial benefits, and so much more. Therefore, not having a trademark is of great disadvantage to a company, as there are issues of future litigation on infringement of trademark by a company who registers under such name. In this instance, the former may bear the loss of giving up such identity. In order not to bear this loss, the owner of the unregistered trademark will have to go through the ordeal of proving that he has been using the mark continuously for some period before the latter registered under such trademark. This was expressed in American Canamid Co. Limited and Vitality Pharmaceutical Limited. As such, businesses are advised to register a trademark for exclusive identification. Innovations in recent years have been on the high side. For a person to enjoy a patent right, such innovator must have registered such innovation. Else, third parties who produce similar products and register the same before the initial innovator have absolute right of excluding the initial innovator from the use, sale, etc. of the innovation and the right to all the benefits that comes with it. This is as a result of the fact that a patent may not necessarily be vested in the true inventor. Rather, such rights is vested in the statutory inventor, that is, the person to file an application for the grant of patents. And this was evident in the case of Uwan Midimo and Command Claim Nigerian Limited and Mobile Producing Nigerian Unlimited. With this, in this light, it is important to state without the fear of contradiction that the importance of patents and trademarks to businesses cannot be overemphasized. Thank you.
Thank you very much, Cindy. So I could hear you pushing, and I think that was an amazing and brilliant presentation. And kudos to your group for putting it together. Well done, Cindy. Okay, so let's hear from group 2. Who will be presenting for group 2? You can just unmute yourself and then share your slides and start. Who is presenting for group 2? Okay, if group 2 is not ready, okay, I can see that. He's sharing his screen.
All right. Good day, everyone. I trust we are all super excited to be here today. I shall be presenting on behalf of Group 2. The topic of presentation is the importance of copyright and industrial design to businesses. As a kid, I grew up on a street where we buy DVDs containing collection of movies by different actors and actresses at a very cheap rate. My uncle will always clamor on how piracy is ruining businesses for these actors and actresses whenever he sees us watching these DVDs. You might be wondering how this is related to this presentation. However, this story illustrates how copyrighted works are being duplicated without the creator's authorization and thereby ruining business for the creator of such work. I am Yusuf Jamiu, an intellectual property law enthusiast and a 300 level law student of Ahmadu Bello University. If you follow me closely, you will learn what copyright and industrial design are all about and their importance to businesses in Nigeria. Firstly, I will consider the importance of copyright to businesses and subsequently the importance of industrial design to businesses. To have a profound understanding of what the importance of copyright are to businesses, it is pertinent to understand what copyright is. In the literal sense, the word copyright connotes the right to make copies of a work. According to US Copyright Office, copyright is a sort of intellectual property that protects original works of authorship once they are fixed in a tangible form of expression by the creator. From this definition, it can be said that copyright covers works such as paintings, pictures, novels, and many more. Also, it is noted that until a creative work is fixed or incorporated in a material or other definite form, copyright for such work does not exist. In Nigeria, the Copyright Act, which deals with copyright matters, does not provide a substantive definition of what copyright is. However, Section 6 of the Act provides that copyright in a work shall be the exclusive right to control the doing in Nigeria of certain acts in relation to the work. Acts which include reproducing, performing, or publishing of the work in material form. It is imperative to state here that not all works will be eligible to copyright, and this will take us to the works that are eligible for copyright. Section 1 of the Copyright Act has highlighted the works eligible for copyright as follows. Firstly, literary works. Secondly, musical works. 3, artistic works. Number 4, cinematography films. Number 5, sound recordings. And number 6, broadcasts. It is eligible for copyright. Furthermore, there are some criteria that must be satisfied before a work can enjoy copyright protection. These criteria are originality, fixation, and qualifying factors. What do we mean by originality? Originality means that the work must be original, that it is generated autonomously by the creator. This criteria for copyright protection does not mean that the work must be fresh or indigenous as under patent law, but the work should show minimal level of ingenuity. As was stated by Pierce LJ in the case of Ladbroke Football Limited versus William Hill Football Limited, originality simply connotes that the work should not be copied. Originality simply connotes that the work should not be copied, but should originate from the author. For example, during the course of research of this presentation, we reference a lot of work of other authors, and this doesn't mean that this work is not original. Secondly, fixation. Fixation means that the work must be in a physical medium. Once a work is sufficiently permanent to allow it to be observed or reproduced, it is deemed to be fixed. And lastly, qualifying factors. What does this mean? This criteria is met once a work has a link to Nigeria, either through its author status, the location of the work, or international agreement. This will lead us to what are the importance of copyright to businesses. Firstly, economic gain. Copyright confers exclusive ownership of money generated from the original work of an author or a producer to the creator of such work. The owner of a protected work has the right to or royalties generated from such work, either through the modification or amendment of the work. For example, FIFA paid Davido and other artists a good sum for them for their music to be used at the FIFA World Cup 2022. Secondly, ownership. Copyright converts exclusive ownership of a work to the creator of such work, thereby preventing other authors from using the work without the authorization of the creator of the work. In the case of Okilo versus Dick Francis and another, the defendant who duplicated the master tape of the plaintiff was held to have infringed the exclusive production right conferred on the plaintiff under the Copyright Act. And lastly, legal penalties. Using any copyrighted work without authorization attracts penal sanction. By the provision of Section 16 of the Copyright Act, a plaintiff may seek for damages or injunction once it is true to him that his copyright work has been infringed. Recently, in the case of TV Extra Production Limited and another versus NUC and Zain Nigeria, the plaintiff was awarded a whooping sum of 703 million naira in a copyright dispute case, which the defendant was found guilty. Having understood the concept of copyright and its importance to business, now we move to importance of industrial design to business. Industrial design is that aspect of intellectual property which focuses on the appearance of a product resulting from the features such as the lines or colors of the product or its ornamentation. For example, Coca-Cola is distinct from other beverages because of the bottle that they use to produce their product. One may wonder why design is so important in the marketplace. The reason for this is not far-fetched, as there are numerous products serving the same function in the market, but they are distinguished from each other by their design. The designs in Nigeria are regulated by the Patent and Design Act. For a design to be qualified for registration, it must satisfy some conditions, which are newness, originality, and public order or public morality. What do you mean by newness? It means the work must be new. It will not have been registered before filing an application for registration of such design. Originality means that the design must be an independent creation of the creator and not an imagination of any previous design. And lastly, public order. It means that such design must not be contrary to public morality. Based on this one, we move to procedures of registration of designs. According to the Patent and Design Act of 2004, the procedures are as follows. Once an application will be made to the Trademark, Patent and Designs Registry, and such application will be accompanied by the following: 1, request for registration of the design; 2, applicant's full name and Nigerian address; 3, specimen or a photographic presentation of the design; number 4, the kind of class of the product; number 5, assigned power of attorney where the application is made by an agent; number 6, evidence of payment of prescribed fees; and lastly, any other prescribed requirements. Once these are attached to the application, such design will be granted design. It will be registered as under industrial design. To show how industrial design impacts on businesses, we have illustrated the Coca-Cola bottle, for example. It is unique in its branding and it attracts customers for the company. It is on this note that we'll move to the importance of industrial design to businesses. Firstly, the first importance is that it is an invaluable asset. What do we mean by this? It means that design helps determine the success of a product. The appearance of a product sometimes goes beyond. The appearance of a product sometimes attracts customers for the product more before they even know what the product entails. Secondly, exclusive rights. Industrial designs help prohibit competitors from copying or producing similar designs to the one that you have registered. It confers exclusive rights to the creator of such design. And lastly, legal protection against infringement. The Patent and Design Act of 2004 has provided in section 16 that a plaintiff may seek for damages once it is clear to him that his design has been infringed. It is on this note that I will conclude that copyright and industrial design are very, very vital to the success of businesses. Nowadays, that businesses are beaming here and there, it will avoid duplication of your work or your design. Thank you.
Thank you very much, Jamiu, and special salute to you on your introduction. It was really attention grabbing. Well done. And the other points afterwards to really hit home. So thank you for the work done. I can see that the next group is on fire. Before I called, they are already sharing their screen. Papalola. Yes, so you have about 9 minutes to be done. Thank you.
Ladies and gentlemen, intellectual property is a 3-letter word. And for the next 3 to 5 minutes, I will be making it rain on you, the silent cash in IP. I'll be talking about intellectual property, the franchising, the licensing, and the exports. Welcome to Commercial IP 101, and I'm your moderator for today. Understanding key terminologies. I bet you were probably wondering, what does franchising, what does licensing, and what does intellectual property mean? Well, in the first part of the presentation, I'll be putting the sense in the license. Utilization. Since we don't talk is cheap and we're completely about money, the second part talks about the utilization of these economic terms. Part, legal intricacies. Because if I may, in the third part of this discourse, we'll be bringing the mallet down on the legal intricacies using judicial precedents. Part 4, illustrating the trends and making predictions for the future. And finally, for the end game, I would have you snapping your hands as we'll be making a predictive analysis to the future of intellectual property. Franchising. A franchise is a method of distributing products or services involving a franchisor who establishes the brand's trademark or trade name and the business system, and the franchisee who pays royalty and often an initial fee for the right to do business under the franchisor's name and system. Technically, the contract binding the two parties is the franchise, but that term more commonly refers to the actual business that the franchisee operates. Looking at it from the point of view of an amateur, this might seem too good to be true, but truth be told, the only freedom is salvation. The manufacturers benefit by getting a massive opportunity to expand their reach and popularize their business. One of the most famous examples of a franchise is McDonald's. From a modest start, the McDonald's franchise now has more than 36,000 restaurants around the world. There are two types of franchises: business format franchise and traditional or product distribution franchise. In a business format the franchisor provides to the franchisee not just his trade name, products, and services, but an entire system for operating the business. The franchisee generally receives site selection, development support, operating manuals, training, brand standards, quality control, a marketing strategy, and business advisory support from the franchisor. While less identified with franchising, traditional or product distribution franchising is larger in total sales than business format franchising. Examples of traditional or product distribution franchising can be found in the bottling, gasoline, automotive, and other manufacturing industries. Licensing, on the other hand, is a limited legal business relationship where a specific party is granted rights to use certain registered trademarks of a brand. The business relationship is between the licensor, the one who owns the trademark, and the licensee, the one who is granted the rights to use them. A very good example of licensing is how Burna Boy's Spaceship Record is able to function as a subunit of Atlantic Warner Music and use their logo and their name while they make music videos. Or DMW, Sony Music, use the registered trademarks of another brand. The licensee pays the licensor an agreed upon royalty fee. In general, the license agreement happens between two established businesses. The licensee is purchasing the rights to use protected marks that are already recognizable and appreciated by a built-in fan base. This makes licensing a secure investment and a great way to boost your business. Two of the most famous brands that operate licensing agreements are Disney and Calvin Klein. Calvin Klein works with a number of manufacturers under licensing agreements. This means that the Calvin Klein company has licensed or loaned its brand and trademarks to certain manufacturers who then use the brand to sell their products. Calvin Klein products such as underwear, perfume, and jeans are all produced and branded under licensing. When you purchase items emblazoned with Disney characters, it's most likely that the product wasn't actually manufactured by Disney. More often, Disney signs licensing agreements with certain producers to use their characters and images, which is why you find Disney characters on everything from soap to sleeping bags to t-shirts and clothing. In general, licensing agreements are most often used by brands that are highly recognizable and marketable. For a licensing agreement to be beneficial to both parties, the business branding must already be successful and known by a large portion of buyers. Now to exporting. The act of conveying or sending commodities abroad or to any other country in the course of commerce. Let's travel for a minute. Exporting intellectual property can be a little complicated, as different countries have.
Okay, I think that he might be having network issues. So while we are waiting for him to join us, the next group can start their presentation. Can we hear from group 4 while we're waiting for? Please indicate if you can hear me so that I'm sure that. Can anyone hear me?
I can hear you.
Okay. Thank you. So please, who is presenting for group 4?
Hello?
Yes, I can hear you.
Group 4.
Okay.
Sorry, ma'am, I'm trying to share this slide.
Okay.
All right, ma. Good afternoon. My name is Wasila Adidakbo. I'm the one presenting on behalf of Group 4, and our topic today is intellectual property management, intellectual property evaluation, trade secrets. Agenda for today, topic 1, what is intellectual property management? What is intellectual property evaluation? What is trade secrets? Introduction. The world is fast developing and individuals are on a daily basis seeking out more creative and ingenious means to go about their daily activities. In a bid to ensure reward for people who put their efforts into providing novel solutions to long-lasting problems through their invention, there is a need to ensure that they have the exclusive rights to explore such invention. This exactly is where intellectual property comes in. Relying on backdrop, this article seeks to address what IP management, IP evaluation, and trade secrets are. In doing this, it shall first begin by defining what intellectual property is. It shall move on to address what IP management, valuation, and trade secrets are, making copious references to case studies in order to aid understanding of each terms. IP valuation. Valuation of intellectual property is the process of deployment to determine the mandatory value of IP assets. The capacity to exclude competitor from a market contributes significantly to the value of an IP asset. The legal rights attached to IP grants an IP owner exclusive ownership. However, the economic rights grants the ability to control the use of IP. There are standards to quantify and appraise IP assets. For an IP asset to have a quantified value, it should, 1, generate a measurable amount of economic benefit to its owner/users, enhance the value of other assets with which it is associated. An IP asset will be separately identifiable to be able to carry on evaluation on the IP. Prerequisites for undertaking IP evaluation include: 1, the IP asset must be subject to specific identification and a recognizable description. 2, there should be some tangible evidence or manifestation of the existence of the IP assets, e.g., a contract, a license, a registration document, a computer diskette, a set of procedural documentation, a listing of customers recorded on a set of financial statements, etc. It should have been created or have come into existence at an identifiable time or time period or as the result of an identifiable event. It should be capable of being legally enforced and legally transferred. It should be capable of having its income stream separately, identifiable and isolated from the contribution of other assets employed in the business. It should be able of being sold without selling the other business assets of the enterprise to the same buyer. It should be subject to being destroyed or to termination of existence of an identifiable time or time period as a result of an identifiable. Management and protection of trade secrets in Nigeria. Despite the increased number of small, sorry for that, it should be IP management and protection of trade secrets in Nigeria. Despite the increasing number of small and medium-scale enterprises and technology-driven startups in Nigeria, the regulation of IP is still limited to patents, design, copyrights, and trademark. This is no doubt impose a challenge on the protection of trade secrets in Nigeria and further raise the concern of possible remedies where such secrets are being breached. In the absence of any definite legislation protecting or regulating trade secrets in Nigeria, the originator of such trade secrets has to put in an extra effort to protect such from being disclosed to a third party or the entire world. Proper IP management is needed to prevent copy of assets, counterfeiting, thefts of intellectual property, abusive use, and so on. Management of IP is strictly based on the management of various intangible assets of companies and individuals, which include but not limited to a name, service, render, and business concept, and so on. A good IP management should include both analysis of competitor and the analysis of risk. IP management. Effectively managing an enterprise IP portfolio help protect that company's data, decreases risk, and enhance compliance with global legislation. It is not enough to simply obtain formal IP rights. Patents and trademark rights need to be exploited adequately. If an enterprise wishes to obtain a maximum value from their IP, it should take effective steps to come up with an IP strategy for their business. An IP strategy should include the following: a policy on IP acquisition, a policy on IP exploitation, a policy on IP monitoring, a policy on IP enforcement. Trade secrets. A trade secret is a company procedure or practice that is not publicly known and provide the company or the holder of the trade secrets with a financial benefit or advantage. Trade secrets, which are often the outcome of a firm research and development, must be actively protected by the company. It could either be a design, pattern, recipe, formula, or proprietary procedure, which distributes the company's products to its clients, while also delivering a compelling edge. Unlike patents, which can be documented, the motion of trade secrets is based on the fact that it is a secret, thus making it rather difficult to govern and defend. Where trade secrets protection is insufficient, the consequence for business could be disastrous. Why Nigerian can be said to be partly indifferent to trade secrets due to a lack of subject-specific legislation. Other countries such as Uganda, through their Trade Secrets Protection Act 2009, and the United States through their Uniform Trade Secrets Act 1985, and the Defense Trade Secrets Act 2016, and the World Trade Organization through Article 39, Trade-Related Aspects of Intellectual Property Rights 1995, have sought to protect trade secrets. The United States Court of Appeal for the Second Circuit found this last provision under TRIP, which is also contained in UTSA, to be pertinent condition for determining whether an information is indeed a trade secret or not in the widely celebrated case of National Mutual versus Montesson. In that case, the court held that the fact that the agency office automation information was in a different, more secure format than the physical folder was not enough to elevate it to trade secret rank. According to the court, rather than the medium of storage, it is the level of protection provided to the data that matters. How can trade secrets be protected? One of the ways through which trade secrets can be protected by drafting a non-disclosure and non-complete agreement with every employee of the business, most especially those who may have come in contact of the trade secrets. In the case of Kumolus versus Leventis Motor Limited, the appellant, who was employed by the respondent and was aware of the respondent trade secrets, resigned and went to work for the respondent's competitor, Nigeria Technical Company Limited. Following the appellant's departure from the respondent discovered that the business plan that was being considered within the respondent's company had now been reviewed and examined by the appellant's new employee, resulting in the loss of commercial potential. Example of IP management. A proper example of IP management is that which was done by German firm Gannon Solicitor for one of its clients, which is a fashion label. The solicitor is managing the intellectual property of the fashion label, made certain that their employment documents were secure. If designs created a new apparel, a line, or accessories such as handbag for the label, they ensure that the label retained IP ownership, even if the label did not manufacture the design. When the fashion label hired designer, the firm made sure that the contract explicitly transfer IP rights to labels. Protection of trade secrets in Nigeria. Cases. Drafting the non-complete clause is critical to ensure that the profession do not run the risk of being declared null and void by the court for being too restrictive. In the 7th Heaven Bistro Limited versus Deaf and Dead, the National Industrial Court found that one of the terms of exclusive employment contract expatriates, where that the employee is not to accept employment with any other employer in Nigeria or the same line of business as the company its shareholder outside of Nigeria for a period of 3 years from the date of termination or resignation was too restrictive. Consequently, the National Industrial Court declared the provision null and void. Similarly, the National Industrial Court in Simpson System and Investment Limited versus Chimoman Infinity Tires Limited versus Kumas and others held that the non-complete clause that prevented the employees from working for 5 years and from working in any other company in Nigeria, respectively, were too strict, hence null and void. Example of IP evaluation. A simulation of IP evaluation was conducted by Thomas Sakalo for the Apple brand in 2011. They adopted the market value approach for valuing the IP rights of the iPhone brand, and the evaluation method revealed, among other things, that as at 2011, the iPhone brand was worth up to $30 billion US, and that 25% of that value is due to iPhone patents. Thank you.
Thank you very much, Eniola. Thank you for the presentation. I think those topics are very deep and serious topics, and it's good that your group was able to explain it in a way that people can understand. Well done. I don't know if Babalola would like to continue his presentation before we call on our mentors to give their comments.
Yes, I would like to.
Okay, please. You can quickly round up. Hello, Babalola. Can you hear me?
I can hear you now.
Okay, please, you can continue your presentation.
Let's talk about exporting. Exporting refers to the act of conveying or sending commodities abroad or to another country in the course of commerce. Let's travel for a minute. Exportation in intellectual property can be a little complicated as different countries have different flexibility on their trademark laws. It's exactly why you bought those sneakers and discovered that your Adidas had 5 Ds instead of 3, while your Puma had the picture of a buffalo instead of an actual Puma. Countries in Asia like China and India have less flexibility on brand piracy. That is why those producers capitalize on the piracy to produce fake goods. Intellectual property. Any product of someone's intellect that has commercial value, a piece of literature, a painting, an invention, a trademark, and trade secrets, works protected under intellectual property law and accorded intellectual property rights. We can't deny the massive effect of intellectual property to technology and economics. And like Moses, I'll be passing the open sea on commercializing your NFTs or even a large-scale business. Let's go to the forms of intellectual property: copyrights, trademarks, patents, trade secrets, and design. Utilization. Trademarks. In a globalized market space, increasingly dominated by web-based content, the protection of an IP right is paramount, and hence the requirement to pay an upfront fee for the use of the intellectual property for the term of the agreement. When IP rights are mentioned in an agreement, those rights also relate to trademarks, know-how, and systems, which essentially represents the brand. This brand is the common identity of the network and is fundamental to the generation of goodwill in the marketplace. Because of the importance of the brand, the licensor will typically exert a lot of influence over the use of that IP by the licensee. Business method patents allow a franchisor to prohibit or allow others from using its claimed unique business model, or at a minimum, the claimed unique features of its franchise system. Any party practicing the invention Any party using or practicing the invention without permission from the patent owner might be held responsible for infringement of the patent. Some franchisors possess patented inventions that are licensed to a franchisee in a franchisee agreement. These inventions could be in the form of business methods, computer software, applications, and equipment hardware. Copyright law is important to the commercialization of intellectual property, both because it can protect aspects of the franchise system and because franchisors and franchisees engage in activities that might expose them to liability for infringement. Copyright laws protect expression, it does not protect ideas. Trade secret, a franchisor may protect the trade secret or know that it makes or the know-how that it makes available to a franchisee through the use of a confidentiality or a non-disclosure agreement. In addition to the foregoing, it is advisable for a franchisor to register the license granted to a franchisee with the Trademarks Registry or Patents and Designs Registry as applicable. For this purpose, a short-form license agreement separate from the franchise agreement will be required. Case laws on franchising. The case of Patek versus Robert Jackson, a former franchisor who carried out a campaign on a website and on social media platform featuring the franchisor's trade name, where allegations were made against the franchisor and his product.
Okay, I think there's a second person that was supposed to round up the presentation if he's having network issues. So I don't know if the second person would like to finish up the presentation or if we should move to our mentors. Okay, so I guess we would move to our mentors to hear from them. So let's call on Lolade to make her comments on the presentation based on her practical experience on the topic. Hi, Lolade, over to you.
Hi, Juliana. Thank you so much.
Thank you so much.
I'm glad. I'm happy to be here. I think the presentations were quite amazing. I mean, seeing young people talk about IP valuation, that's so interesting. IP valuation, licensing and franchising. As the last speaker was speaking, it just occurred to me that, franchising and licensing is something that we need to explore more, right? In this region of Africa. It's very important. It's something that people don't know about, people don't talk about it. And I just figured that in most of the presentations, right, people kept on talking about foreign cases. We had just few Nigerian cases just to show you that nothing really is happening around here. And, there's a need for us to push further, to spread this information about the importance of intellectual property. So, that was quite good. I actually enjoyed the presentations, amazing presentations, well done. So I don't know if you have questions for me, particular questions that you like me to answer. Yeah.
Thank you. So we wanted to hear your comments first on the topic based on your practical experience, and then we'll also hear from Amarli before we take the questions.
Okay. So in terms of let's start with trademark, right? So we spoke about the importance of trademarks, how it is critical to businesses, right? And I think that trademark is quite important, right? It helps you to differentiate your brand from another. And one of the things that SMEs and big businesses need to do is to sit down, right? Come up with a strategic brand strategy. That is what influences, the kind of trademark you'll be looking at, the kind of mark, whether it's a mark, whether it's a logo, whether it's a slogan, it doesn't have to be fixed. So I know of an institution that what they use is a mark. They don't have a name. They have a name, but what they trademarked is the mark. I don't know if you understand. So they actually have a name that they are working with, but what they trademark is the mark. And that works for them. So even when you see the mark, you are like, wow, because the mark communicates the essence of what they are, the essence of what they do. It communicates their value and how they are positioning in the market. So I think trademark is critically important, critically important. Then moving on to, licensing, franchising. I mean, even small businesses can make the best of licensing. You just need to have the right people on your team. You need to have a solid plan, and you need to move towards it. You can enter into foreign markets with a smart strategic licensing plan. I mean, it works. There's how to go about it, right? So I think that's also critically important, right? So the licensing, the trademark licensing is very, very important. Now, when it comes to patents, really, patents basically will protect your innovative ideas. It will protect your invention. Then if you have come up with something better than what somebody else has done, patent would also protect that. And so the patent market is highly competitive, really, really competitive, because what happens today can become something else tomorrow. So patent doesn't really work for the rapidly innovative industries, right? Because once you have something new and another person improves on it, yours becomes obsolete. And if the person obtains a right, the person is gone, right? So where patent works the most is patent works with industries in pharmaceutical, the manufacturing industries, what inventions are they using to produce their unique products. Patent works mostly in the energy sectors, pharmaceutical, manufacturing, industrial. That's where you can really enjoy that, that unique, exclusive. But when it comes to the rapidly innovative space, you can have a patent, but in a short while, another person has come with something and they are gone. So that's that with patents. So there's that aspect that business owners need to be careful about in terms of patent. When it comes to exporting as well, I mean, exporting pretty important too. The IP concept is really important in exporting, because if you plan it properly, you can enter into certain markets that can explode your business and grow your revenue streams. So exporting intellectual property, very important. And I think that SMEs need to be more educated. We need lots of partnerships. We need lots of engagement. We need lots of collaboration. Lots of work have to be done in order to just educate people and make them see why intellectual property is important to their business. So that's my short, brief introduction. Thank you.
Thank you very much, Lolade, for that comment and for stressing more on franchising, licensing, and why we need to have that business strategy. Especially as lawyers, I think that it's very good that we pass across most of these advantages to our clients, because if we don't pass it across to them, they will just continue what they are doing as long as they have their company registration. But as a lawyer or as someone who is knowledgeable about intellectual property, it's good that you know about all these things and make sure you communicate it to your clients. So let's go ahead to hear from Amarli.
Hello, good evening.
Good evening.
Can you hear me?
Yes, we can hear you. Thank you so much for joining us.
Yes, I'm very happy to be here. Okay, I will give a global view since I'm IP strategist, and I prefer to give small advice related to IP strategy or IP management, because they took time to present intellectual property globally, but I have to underline that the presentation was good, okay, actually, but they didn't talk about the aim of intellectual property registration. Because when you want to register your brand or your patent and so on, the idea is to have exclusivity. We have to insist on it, because the exclusivity makes that you can stop the other people who wants to copy you. That's the first thing. After that, you are looking for distinctiveness when you go to the market. The distinctiveness helps you to be distinguished to your competitors. That part is very important for the company who wants to have a good position into the market. I also want to ask them to often think about the question, why should I have to register one of my IP assets? Because we cannot choose to have an intellectual property asset just to have it. When you want to register a patent or to register a patent or a trademark, industrial design, or any other IP asset, you have to have a specific plan, because each asset helps you to achieve a specific goal. So the registration is not something that we choose like that, you see. And the best approach, since we know that actually we have more than 80%, from time to time, 90% of assets of each company who are made up of intellectual property, means that if you have a company now, you have to have an IP strategy, or you have to implement an IP management, you see, in order to match your intellectual property strategy with your marketing strategy. For me, I think that the legal advisor have to work closely with the marketing department, because both, when they mix the strategy, they can easily achieve the goals, okay? So at the end, generally, it is a mixture of different IP assets that help the company to have the best results. So you have to choose, maybe you have something like this bottle. With this bottle, you can have a patent, you can have a trademark, you can have an industrial design, you can also have a copyright. But at the end, sometimes it just depends on the company means, because if you don't have a lot of money, you can choose just to register a brand or just to have a patent, let's say that. I also want to ask them to insist on the exploitation of intellectual property. When they want to extend the right into another country, they have to take some information before. Because if you want to go to Asia, for example, you have to know that maybe your brand cannot be received well in this country. So you have to work with your local attorney there in order to check if your brand have any signification. You have to choose the correct countries when you want to enter. You have even to plan, because intellectual property has a specific cost. If you don't have money right now, maybe you can plan to go in this area in 1 year, in 2 years, and so on. So exporting intellectual property, it is a part of a whole strategy. It's something that has to be planned. So globally, this was the main point that I wanted to underline on their own presentation. The last but not the least, they have to know that intellectual property rights are not only important for companies. Intellectual property rights are also important for the whole society, because actually we have drugs for coronavirus. Thanks to intellectual property, we have roads, we have many things I'm discussing with you thanks to intellectual property. So they also have to retain that intellectual property is not only good for the owner of the intellectual property, but also for the whole society. Thank you.
Amazing.
Thank you very much, Amrali, for that presentation. Thank you for talking to us about the global view, about why we need IP, and the exporting and the management side of it, the cost side to it, because we know that a lot of people shy away from it because of the cost. So it's good that we have these different perspectives to the discussion. Thank you so much, Amrali. Thank you so much, Lolade. So I'll be handing over the discussion to Jude to take the Q&A. Hi, Jude.
Hello, good evening. Good evening, everyone. Can you hear me?
Yes, I can hear you, but it's breaking.
Hello, can you hear me? Am I clear now?
Yes.
Okay, I'm so sorry for joining late. So we have a couple of questions here. I'll be directing them to the mentors one after the other. Have up to 6 questions. So I will take them one after the other for the mentors to respond to. Okay. First question here goes, what kind of protection does a trade secret offer? What kind of protection does trade secrets offer? So I think I should also type that in the chat box. Yeah. Okay.
Okay. Can I respond?
Yes, you can. Thank you.
Yes, please.
Okay. A trade secret, we have to know that each company has trade secrets. Maybe the way you are developing a specific product, your clients list, short list, and any other information that is really important and that has value for your company. So the type of protection that brings the trade secret is to help you to prevent the other people to use this information that has value for your company in order to keep your position into the market. Let's take an example. If you have an employee and maybe he's the one who often writes the process to obtain a new milk, okay, drink milk, and that employee wants to resign for any reason, okay, you have to ensure that when that employee resigns, he cannot go with your trade secret, or he has to keep all this information on his own side. Because if he goes to another company and share this information with them, they will know how you proceed to obtain your milk, and you cannot be competitive with time. So that is the aim of trade secrets.
Amazing. Thank you very much. Just to add to that, I mean, Amelie mentioned the importance of having to protect it, right, from with employees, so that employees don't take your intellectual property and your trade secrets, take them to another competitor, and before you know it, your competitor is actually ripping off the hard work you have, gathered in so many years. So in addition to that, basically trade secrets is more on it's something that protects the confidential information that your business has. So it's a type of intellectual property that protects the confidential information that your business owns. So when I mean confidential information, is an information that has a commercial advantage, right? It's something that you have used over and over and over again in your business, and you're too sure that this information has a positive impact on your business. Either it has the ability to attract premium clients for you, either it has the ability to increase. Can you hear me?
Yes.
Amazing.
Yes, I can hear you.
Either it has the ability to increase your revenue streams. I mean, it's just confidential. You have access to it. You use it anytime, any moment, and you see the results. So one thing about trade secrets is that it actually has a commercial advantage. And as a business owner, as a founder, as a CEO, right, as a creative, you know that this thing is a business asset to me because it has a way of just growing and expanding my business. So every business, literally every thriving business, has a trade secret, and it's important that we take measures. Measures have to be taken to protect those trade secrets, to ensure that another person does not take that trade secret to another place, right? So I believe that one of the things that SMEs do, one of the things that lawyers and IP strategists do for small companies and founders and entrepreneurs is that they help them to draft non-compete clauses, right? I believe somebody mentioned it during the presentation. So, right, so you draft a non-compete clause
Sorry, we can no longer hear you. Am I the only one?
Yeah.
Oh, wow. Can you hear me now?
Yes, we can.
Amazing. Okay, so I was saying that Amile also mentioned that it's important that you prevent your employee from taking your creative trade secrets to another competitor, right? So I said one of the ways we get that done is that lawyers, IP strategists, they draft non-compete agreements, right? We draft it for people in business, right? And so the purpose of that is to prevent an employee from taking your trade secrets to another competitor. Usually the usual practice is about a year, thereabouts. A year, but if it's like 5 years, I mean, somebody mentioned during the presentation that once it's 5 years, it's going to be nullified, because sometimes people take their bosses to the courts, and they and they have to like drag over the issue of, oh, why can't I go to a competitor, right, to work for a competitor, have a right to work in any place where I want to work. So usually like for 1 year. And what I advise people to do is that I advise people to actually, employ other protection mechanism. You can use cybersecurity measures, right, to protect your trade secret, depending on the industry you're operating in. I mean, sometimes even your trade secrets can just be between 2 to 3 people in a company, people who are trusted advisors, right? Between 2 to 3 people in a company, and you guys sign a non-disclosure agreement such that if anybody breaches the content of that non-disclosure agreement, there will be liabilities, there will be damages. So, I mean, these are some of the ways we can actually curb the leakage of trade secrets. Yeah, thanks.
Okay, thank you so much. Hope that was satisfactory enough. Our second question here is, what is needed to prove in a trade secret claim? So, I believe Lola can still respond to that.
Yeah. Yes, but I can add something, because she started responding to that.
Okay.
She mentioned that we have to have a non-disclosure agreement, means that we take some disposal in order to keep the secrecy, okay? But it is also important to have proof, because if you have a litigation, you have to show that the adverse party has already used your trade secret, you see. So the company who has trade secret has to take some specific measure to ensure that other people cannot use it. Okay, you can have a specific space where people don't have access. You can have the non-disclosure agreement and many other types of disposals, but you also have to follow up your competitors so that if they use your trade secret, you can have some proof. Your proof can come from the website or from any other types of information that you can collect in order to prove that they have already used your intellectual property. We also have to know that for trade secrets, there is a specific way to defend them. When you have a litigation on trade secret, you have to use an unfair competition procedure. I don't know if it is the same in Nigeria, but here in Cameroon, you have to use this procedure in front of the judge. So that's my contribution.
Thank you very much. That was so insightful. And I must add that, okay, based from what you have said, record keeping is very important to serve as a proof. Thank you, ma'am. So I don't know if Lola has anything to add to that before we move to the next question.
Yes, so in terms of what is needed to prove a trade secret claim, basically in Nigeria, there's really no standard procedure because we don't have laws that govern, that aspect of intellectual property. We don't have laws that govern trade secrets. But what usually is done, the practice is to ensure, because sometimes when you want to prove that, oh, you've actually, you've infringed upon my intellectual property rights, you have taken my trade secrets and you have done something else that you shouldn't do with it. So sometimes when you want to prove that, what you have to do is you have to be sure that there's enough notification, right? There's enough notification on your part, so that the infringer will not raise a defense that he was not aware that was a trade secret. So there has to be enough notification. So either you are marking your documents confidential, either you have established procedures in your organization for protecting trade secrets, whatever medium you want to adopt, you must make it clear that, right, you must have an established notification that this is an intellectual property, this is a trade secret. Everybody must be aware, because we've had situations where people will come and say, oh, I'm sorry, I didn't know it was a trade secret. And that's a very big defense, right? Once you're not aware, it's a big defense, but you have to establish those procedures for notification. Another thing is that, I think I've mentioned that before, is that the trade secret must be of commercial advantage. It has to be something that you have applied over and over and over again, right? So it has to be something that you have applied and you know that this is actually a business asset to my company. So the trade secret must be confidential, right? So once it's confidential and you're sure and you're certain that it's confidential and there is a breach, or maybe somebody else takes it and they use it for something else, then you have a claim, right? You can prove that, yes, it was actually used. You can prove that, oh, my trade secret was actually taken and was used, because you know that it's confidential. Another way you can actually prove this is also, you can also prove that your trade secret has been obtained illegally. Maybe there was a disclosure somewhere and is evident, right? Or maybe there was an hack on some of your technical solutions and technical inventions, and it's clear that this is what happened. I mean, those are some of the ways that you can actually prove your trade secret in a trade secret claim.
Yeah. Okay. Thank you. I believe this has been sufficiently addressed, and indeed there are many ways trade secret can be proved, and I hope participants have taken note of all of them. So the third question here is, considering the fact that copyright relates more with the creative industry, is it okay to say that it affects only the creative business? Should I repeat that?
Can I?
Yes, you can. Thank you.
Okay. It's true that copyright is mostly related to the creative activities, but for me, I think that we cannot rely that it is only for a specific type of business, because if you take time to check all the business, any business starts with an idea, and after idea, we often write or describe what we want to implement. And that aspect is somehow a part of copyright, because if you have originality there, you can use it. So for me, you have copyright everywhere, but you just have to know how to put it up so that people can clearly recognize that this one is a part of copyright because you have a written aspect. Let's take an example with a small company. If maybe you have a software is eligible for a patent, okay? But patents are a bit expensive. So at the beginning, you don't have enough money to go and register your patent. You can just write some specific aspects of it, so that you can go here in Cameroon, when you have already written this aspect, you can go in front of, how do I call it? A legal representative, not an attorney. Oh, the name is missing, but in Europe, you have a specific box where you can just keep the information, this description, so that if you have a litigation, you can take this description and demonstrate that I'm the one who written it. I have this specification of my patent. I written them maybe 4 years, 5 years ago, and now I'm claiming the ownership because this person, maybe they have access on it, you see. So for me, we have copyright. We can have copyright everywhere. It just depends on how we implement it into the company or into the business that we have to develop.
Okay, great. Thank you, ma'am, for your response. Don't know if Lola also had something to say.
Well, I think Amila has basically said it. We know that copyright basically protects literary works. It protects books, sound recordings, majorly creative works, cinematographs, photographs, and all of that. But it also protects computer programs. It protects databases. It protects software applications. Like she rightly said, your computer programs and your software applications can be protected by patents and can also be protected by copyright as well. So it extends beyond just creative works. You can also bring it to your software programs and your database too. Yeah.
Vicky, please,
Okay.
if I might just add, I would just like to say that even for franchising, there is a way that the place should look, like the look and feel, and then there are the manuals that they use. So if there is a particular manual that is synonymous to that particular franchise, it will be duplicated in the other centers. So that is also, that would also fall under a copyright. Then for those in the pharmaceutical, the pamphlets, those things that are written, that are put inside the drugs for you to read the instructions and all that, that would also fall under copyright, things that are written on it. So I think it's just for you to know in what aspect of your business you would actually need the copyright. Thank you.
All right, thank you so much. So in summary, copyright does not affect only the creative business. The fourth question we have here is, are there some disadvantages of trademark and patents to businesses?
Okay, for this question, I will start with the patents.
Are there some
Sorry?
disadvantages, patents, and copyright? Okay. Yes, you can go on, ma'am.
Okay. For this question, I will say that the main disadvantage, either for patents and trademark, is the duration, because people are complaining that they have already registered something and after a short period of time, they have to renew for trademark, or for patent, there is no renewal. You just have to, patent, when you register it for the first year, you have to maintain the right till the 20th year. So after the 20th year, it is already finished. Since if you want to keep rights around your invention, you have to see how to match another IP asset on it. So the challenge here is to ensure that if you introduce your demand for patent registration, you can have it yearly, because patent registration takes time. And that is another problem. When it takes time like that, Many offices don't take it in consideration. They just know that you have 20 years, but generally you don't really use your patent during 20 years. You often use it something like 15 or 16 years. So it is somehow disadvantageable for you, you see. And another thing for patent is that you have to publicize the information that make your patent strong, or the criteria of your patent. You have to publicize them. It is an obligation, okay? For trademark, as I said, after 10 years, you have to renew. And if you miss to do that, it's true that you have small time to recover your right, but after this period, if you are not done it, you will lose your right. So that are the main disadvantages of patents and trademark. But for me, I prefer to say that it is not really disadvantage. People just have to understand that when you have intellectual property, assets or rights, you have to follow up them, because many people just register and after that, they don't take time to follow up what they have registered. You see, your intellectual property rights are into the market. You have to follow up and put into your mind that after a certain period of time, you have to maintain for patent or you have to renew for trademark. Thank you.
Okay, thank you, Ma. Okay, Lola, do you also wish to say something, or Convener too? There's more to say on this question.
Generally, I think that, I think that trademarks and patent, they actually have a lot of business advantage. I mean, we've discussed a couple of them before now. There's a lot of business advantage from establishing your brand, to growing your revenue streams, to protecting your innovations, right? So there's a lot of advantage, but there could be some little disadvantage, although that's not what I think SME should focus on, but there could be a little bit of some disadvantage. So if we start with trademark, I think sometimes protection limitation can be a disadvantage. Trademark is territorial, intellectual property is territorial. So what that means is that wherever you protect your intellectual property, if you protect your intellectual property in Nigeria, you can't enforce that right in Cameroon. You can't enforce that right in Ghana, right? Because it's territorial. So that right is basically for Nigeria. So I think that's one of the limitations, except maybe you want to go through WAPI, or you want to go through ARIPO, that's the African Regional Intellectual Property Organizations. And sometimes, there could be a little bit of cost involved, or maybe you want to use the WIPO system, to protect your intellectual property internationally. So there's that limitation to a geographical location. So I think that's the first limitation. Then another thing in respect to trademark, another limitation or another disadvantage is that when you're exploring trademark licensing, sometimes there could be some disadvantage. If you have, granted a license to a licensee, right, to use your trademark for business purposes, it's possible that they don't make profits. It's possible that there's no sales, right? So if there's no sales, it means that there are no royalties. So that's why when you're exploring trademark licensing, you have to consider all the possible options and make sure that your licensee is a right fit for what you want to achieve. So that's another disadvantage. Another disadvantage which I think that some SMEs make is having to use descriptive trademarks. So what do I mean by descriptive trademarks? Is when the name of your product is actually your trademark, is actually the name of your trademark. So instead of using fanciful words like words that have never been created before, I mean, if you look at most of the thriving trademarks that we have today, these are words that have never been created before. Look at CUDA. look at Exxon, look at Apple. I mean, these are words that have never been created before, but somehow they have a strong brand loyalty. Why? Because these people have employed the strategy. They've employed the strategy of using fanciful words. So when SMEs go and use descriptive words, descriptive trademarks, it doesn't really, because well, it's not new, it's not unique. So it doesn't really command that brand loyalty as it should. So these are some of the disadvantages with trademarks. Then when we speak of patents, I think the issue with patents is actually the costs. Sometimes people are like, I'm supposed to be making money, I'm supposed to be cashing out in my business. Why should I be using my business profits, to actually file for patents? And I think Amile has spoken a bit about that. So the disadvantage could be cost, but if you look at it from the other side as well, you realize that when your patent is actually filed and protected, it brings a lot of benefit to your business, from ability to raise funds, to ability to attract investors, to having a strong profile among your competitors, and so on and so forth. So that could be a disadvantage in the eyes of small companies who are just coming up. Then another thing that I would like to mention is that for patent, I think I've said that at the beginning of my presentation. For patents are usually very, very effective in the pharmaceutical space, industrial spaces, but when it comes to industries where technology is rapidly evolving, there is that thing of, oh, another person has improved on what you have done before, and now they now have an existing right over it. So that could be a disadvantage to somebody who has started something, and then there's another person who now does something that is more inventive or improves on that innovation in such a way that it now affects the rights of the initial inventor owner. So those are basically some of the disadvantages with trademarks and patents.
Okay, that's much. Thank you so much for your responses. And I want to ask this question, the response of which may be a kind of summary on this, that despite these disadvantages, can we still be right to say that advantages of registering or applying this intellectual property still outweigh the disadvantages, and then it's not actually a discouragement?
According to the advantages of intellectual property, I think that it is not a discouragement. Intellectual property can be expensive. Intellectual property can be territorial. Intellectual property can be something that has to be managed, okay? But I think the advantage of intellectual property are much more considerable than the disadvantage. Because let's take an example of somebody who built a business. You have a strong business, maybe in Nigeria, and your business has already have something like 10 years. And after 10 years, you have somebody who just appeared somewhere and who started using your brand. You have not yet protected your brand. How are you going to defend your brand, your business? How are you going to keep your investment? How are you going to demonstrate that you are the owner of this investment? So at the end, even if you turn it on the different side, I think that intellectual property is definitely good for each company, for each owner. But we understand that intellectual property is quite expensive from time to time. That is why the small company has to work with IP attorney or advisor in order to see what are the IP assets they can take at the beginning stage of their business, since they don't have money. Because we have many types of intellectual property assets, like copyright. Copyright is for free. So we just have to see which one can fit with your means at the time where you start your business. So this is my contribution.
Oh, great. Thank you, ma'am. Our next question here, the participants want to know the difference between franchising and licensing.
Okay, so when it comes to franchising, it's more like you're giving out a right to another party, right, to use your intellectual property, to use your branded elements, to use your business model, to use your operating model. So it's like you're giving out a whole lot. You're giving out your intellectual property, you're giving out your business models, you're giving out your operating models, you're giving out your branded elements, right? So when you're giving them out to a third party so that they can use it to also grow and expand their businesses. Now, depending on the arrangements between yourself and the other party is known as the franchisee. The party that is giving out the rights is known as the franchisor, right? So when you're doing all of that, you're giving out a whole lot. But when it comes to licensing is like you're just giving out your intellectual property, you're giving out your trademark, you're giving out your patents, or you're giving out your industrial design. So you're giving out an intellectual property to another party to use it to grow and expand, their business. So the model for franchising is quite expensive. Is more expensive than that of licensing. For the licensing, you are simply giving out an intellectual property to a third party to use it to grow and expand their business. But for the franchising, you're giving out a whole lot more. You're giving out the intellectual property, you're giving out the business models, you're giving out the operating models, you're giving out your branded elements so that those businesses can be sustainable and so that they can thrive. So that's basically the difference between the franchising and the licensing model.
Yeah,
Right.
I just want to add one thing. According to the franchising, the franchisor has to give an assistance to franchisee in order to ensure that they respect a specific way maybe to produce the product or to deliver the services, you see. So the idea is to ensure that the business model that has been developed should be really respect, you see. So they give this assistance, but on licensing, I just give my brand to somebody and he's the one who uses it according to the agreement that we have.
You're muted, Jude, sorry.
Oh, thank you for reminding me. Yes, I was about reading out the last question, which flows from the fifth one. Now, we know that there are terms both in franchising and licensing. So the participants wishes to know what other protection do creatives have aside those terms of the franchising or licensing agreements?
Sorry, I didn't get the question well.
Okay, aside the terms of the franchising or licensing agreement, is there another protection that creatives have? Let me simply read the question as it came. What protection do creatives have aside the terms of the franchising or licensing agreements? I don't know if that's clear.
So let me take that. Creatives can also explore. They can explore all other forms of intellectual property. I mean, they can explore trademark protection. They can explore industrial designs, right? So we have some creatives who are tailors, right? They are fashion designers and mega fashion designers, and they do amazing things with their lines, their colors, combinations. There's how they combine it. We have a whole lot of fashion houses doing great things. So it depends on the protection you want to choose. So you can actually choose a trademark protection to protect the name of your fashion brand. You can actually use an industrial design. You can use an industrial design to protect, the lines, the combinations, and the patterns that you're using in your business. You can even use a patent protection to protect the uniqueness of what you're doing, right? So apart from having to focus on copyrights and all of that, you can also explore the trademark protection. You can explore industrial designs, and you can even explore patents, depending on the uniqueness of what it is that you're doing. So that's my addition to that.
Okay, thank you so much. So before we round up, I don't know if there's any addition from Amelie.
Hello?
Okay. Yes.
Yes. My battery is almost. I don't have any contribution. I thank my colleague for her own contribution that I think that is complete.
Oh, okay, thank you. Yes, so to our mentors and participants, this is how far we can go with today's session. Thank you. A very big thank you to our mentors for honoring the invitation. We thank also our convener, Juliana, who has hosted this session also. And we thank all our participants for being here from beginning to the end. And we look forward to having you the next session. Thank you, everyone.
Thank you. Thank you very much, Jude, for an amazing anchoring. Please, I would like everyone to put their videos on. I want us to take a picture. So just kindly put your video on. Let us take a picture. When you take this picture, I would like you to write what you learned, and then I would like you to post it on LinkedIn and tag your mentors and say what you learned. So put your game faces on. Face as in like the right side of the camera, the part that is good for your face. Yeah. Wow. Grace, I can see you. Sumi Bola. I can see you all. Yes, please put your videos on, take a picture, write on LinkedIn what you learned, and then tag your mentors. Tag your mentors. I can see Eniola. Yes, put your videos on. So while we are taking the pictures, I would like to say a big thank you to Armali. Thank you, Lola Day. All those who presented beautiful presentations. Thank you for cooperating with one another. For Jude, thank you. My virtual assistant for last year is here, Omotoye. Thank you so much for coming. I've missed you. Everyone, yes, take your picture, take your picture. I wish everyone an amazing weekend. Have a lovely time. Try to rest and prepare. If you know that someone in your group is tired, please encourage them. Yes, Adebimpe, Esther, Akinwumi, Eniola, Halima. Thank you, thank you, thank you. I can see some too here. Jamil, Yusuf, yes. Thank you all. Love you all. I can see Sam also. Love you all. Have an amazing weekend.
Thank you so much for having me. I'm grateful.
Thank you.
Laura J.
Bye. Thank you.
Bye.
Thank you, Amarli. Bye. Love you all. Thank you, Jude. Bye.
Yes,
Bye,
you.
everyone.
Bye, ma.
Bye.